I'm Simon Goldberg, QC, and I'm head of the Business and Property Group here at Trinity Chambers. This is the latest instalment of the Business and Property Group's webinars. You're going to hear 3 talks today. The first is from me on the concealment provisions of Section 32 of the Limitation Act. Then you're going to hear from Matthew Crowe on the new rent recovery regime, the Commercial Rent Coronavirus Bill 2022. And lastly, you're going to hear from Seth Kitson on post-trial amendments. Section 32 of the Limitation Act is concerned with the postponement of the limitation periods provided for by other sections of the Act in cases of fraud, concealment or mistake. Section 32(1)A is concerned with fraud and 32(1)C with mistake. Today I'm going to focus on Section 32(1)B, which is, when read with Section 32(2), concerned with concealment. The purpose of all 3 limbs of Section 32 is straightforward enough. It's to ensure that limitation does not start to run where the claimant, through ignorance brought about by the improper conduct of a defendant, is not aware of the accrual of their cause of action and time has started to run. It can be a useful tool in the litigator's kit where an apparently stale claim has a whiff of impropriety on behalf of the proposed defendant. However, in practical terms, Section 32 is an area of significant complexity. Concealment has always created a particular difficulty, possibly due to the language of the statute, which, as we will see, is open to several different interpretations. It is, to be honest, a complex area. However, there is light at the end of the tunnel. Some much needed clarity emerged last year from the Court of Appeal in the case of Canada Square Operations Limited and Potter. And unlike many of the cases on Section 32, Canada Square wasn't concerned with a multi-million-pound complex multi-jurisdictional fraud. Refreshingly, it was all about a PPI policy, which the claimant, Mrs. Potter, paid under £5,000 for. I think that helps us make more sense of what is undoubtedly a tricky area of law. In my experience, it's always easier to apply difficult principles of law to familiar factual situations. And, both on a professional level, sadly, and a personal level, happily, I have a lot more to do with PPI than I have to do with multi-billion-pound frauds. But before we get to Canada Square, it's helpful to set the scene and explain where the confusion arose. Section 32(1)B extends the limitation period where, and I quote, "any fact relevant to the claimant's right of action has been deliberately concealed from him by the defendant," close quote. The key concept is therefore one of deliberate concealment. Those words have caused no end of difficulty over the years, however. Deliberate can describe a number of different states of mind. Concealment is a word that can describe a wide range of actions, from physically hiding an object, to destroying documents, to telling a lie, to telling something which is not quite a lie but not quite the truth either, to just not saying anything at all in circumstances where a failure to do so would give a misleading impression. Section 32(2) is a deeming provision in that it deems certain behaviour to amount to deliberate concealment. It provides, and I quote, "deliberate commission of a breach of duty in circumstances where it is unlikely to be discovered for some time amounts to deliberate concealment of the facts involved in that breach of duty," close quote. Now, for a deeming provision, it might be said that Section 32(2) serves to muddy the waters rather than clarify matters, because it raises a whole raft of further questions. What does deliberate mean? Is it the same meaning as the deliberate in Section 32(1)B? What does unlikely mean? How unlikely does discovery have to be? How long is some time? Is a month long enough? Is 6 months? And what amounts to a breach of duty? Is it any legal wrongdoing at all? Some of those questions have been answered in the case law. Some still wait an appropriate case before they're answered. It's helpful to mention 3 cases before we get to Potter in order to understand the confused state that the law had got itself into and which the Court of Appeal clarified. In Cave and Robinson, Jarvis and Rolfe, the House of Lords in 2002 decided that deliberate commission of a breach of duty meant that the defendant knew what they were doing was a breach of duty. Lord Scott explained that a claimant could show deliberate concealment of a relevant fact either by a positive act of concealment or a withholding of relevant information, provided that in either case he could show an intention to conceal the relevant fact. This was the first time that a distinction had been drawn authoritatively between what became known as active concealment on the one hand and a failure to disclose on the other. Lord Scott explained that proving the requisite intention to conceal might be difficult and that Section 32(2) provided an alternative route which focused not on the concealment itself, but rather on a deliberate breach of duty. Williams and Fanshawe, Porter and Hazelhurst was where the problems really started. That was a case in which a solicitor had failed to inform his client of a negligent act which had caused the client's claim to be dismissed. The Court of Appeal in 2004 held that in order for concealment to be deliberate for the purposes of Section 32(1)(b), the defendant must have, in the words of Mr. Justice Park, considered whether to inform the claimant of the relevant fact and chosen not to. Lord Justice Mance held that as a solicitor had a duty to keep the client updated about a case, his failure to do so amounted to deliberate concealment. But, and it may be that this was what sowed the seed of confusion, he went on to hold that in the absence of a duty to disclose, a failure to mention a relevant fact might be deliberate, but would not constitute concealment. The third case was AIC Limited and ITS Testing, which is known as the Critty Palm. In that case, ITS was engaged by AIC to test a cargo of gasoline and certified that it met its specification. ITS used the wrong test and certified that the cargo did meet its specification. When, after delivery by AIC to its buyer, the buyer raised that the cargo did not in fact meet the specification, the defendant undertook a retest which showed that the gasoline was not of the correct specification, but didn't disclose that fact to the claimant, stating that it would stand by its certificate. The claim was brought outside of the primary limitation period, and so AIC relied upon Section 32(1)(b) to argue that ITS had deliberately concealed its failure to conduct the correct test. 3 judgments were given by the Court of Appeal. All agreed that this was a case of failure to disclose rather than active concealment. All agreed with Lord Justice Mance in Williams that in such a case there must be a duty to disclose before there could be deliberate concealment in a non-active concealment case. So far, so clear. Now for the confusion. Lord Justice Ricks held that the duty to disclose, which had to exist before there could be deliberate concealment, was a pre-existing duty owed by ITS to AIC in contract or tort. He found there was no such duty, and so there could be no active concealment. The majority, however, held that there was a duty to disclose and ITS had breached it. However, what was not clear from their judgments was whether the duty to disclose that they found was a pre-existing duty in contract or tort, or a freestanding duty to disclose which arose under Section 32(1)(b) based upon common sense or fairness. If it was the latter, this represented an extension of the law as previously understood. So that's where we were pre-Canada Square. The facts of Canada Square will be familiar to all of those who cut their teeth on PPI claims and to those who are now cutting their teeth on PPI claims Mark II, which is the Plevin claims. In 2006, Mrs. Potter took a loan with Canada Square for a little under £17,000 over 54 months at 7.9% APR. She was advised to take out PPI and was loaned £3,834 to cover the cost of the policy, which with interest came to a total of £4,545 to repay. Mrs. Potter was not told, of course, that the premium payable to AXA for the PPI policy was £182.50 and that the remainder of the £3,834 she paid was Canada Square's commission. In April 2018, Mrs. Potter was paid £3,160 in compensation, and in December 2018 she issued proceedings to recover the balance of the sum she paid for the policy, together with interest, and she relied upon the provisions of Section 140A and B of the Consumer Credit Act 1974, which, as we know, permits the court to make an order for the repayment of the premium where it's satisfied that there was an unfair relationship between lender and borrower. Mrs. Potter's loan agreement had come to an end in March 2010, and it was common ground that the limitation period which applied to her claim, which is the limitation period under Section 9 for claims under statute, had expired in March 2016, subject to the application of Section 32. When Canada Square, in its defence, raised a limitation defence, in her reply, Mrs. Potter relied upon both Section 32(1)b and Section 32(2). Her case on Section 32(1)b was that Canada Square had deliberately concealed the receipt of commission from the insurer and its amount. Her case on Section 32(2) was that Canada Square took a deliberate decision not to disclose the commission it received, and that was a deliberate breach of duty which was unlikely to be discovered for some time. The claim was heard at first by a recorder, a part-time circuit judge. It's not clear why it was heard at that level, because it was a small claim and normally would have been heard by a district judge or a deputy district judge. Anyway, Mr. Recorder Rosen QC held that Canada Square's non-disclosure of the commission arrangements was intentional, or at least reckless, that it must have known that it was acting unfairly for the purposes of Section 140A, and that it must have known that Mrs. Potter was unlikely to discover the payment of excessive commissions unless told about it by Canada Square. He therefore held the claim was not statute barred. On appeal, Mr. Justice J upheld that decision. He found that for the purposes of Section 32(2), Canada Square were to be taken as knowing that they were under a duty to act fairly under Section 140A and to have taken a deliberate decision not to disclose the commission where it was obvious the commission would not be discovered for some time. However, faithfully applying the reasoning of the Court of Appeal in Williams and in the Critty Palm on Section 32(1)b, Mr. Justice J held there was no freestanding duty to disclose the commission, so that there could be no concealment without reliance on Section 32(2). Canada Square appealed on a number of different grounds. The Court of Appeal rejected Canada Square's argument that the creation of an unfair relationship under Section 140A was not sufficient to constitute a breach of duty for the purposes of Section 32(2). That's helpful for those pursuing these claims outside of a primary limitation period, but I want to focus on the findings that the Court of Appeal made on concealment. It was not in dispute on appeal that the existence and size of the commission was a fact relevant to Mrs. Potter's cause of action for the purposes of Section 32(1)b. The court then went on to make three findings which are of general application and significantly clarify the law in this area. First, that Section 32(1)b is not limited to cases of active concealment. It can also apply to a mere failure to disclose a relevant fact. However, the distinction between active concealment and a failure to disclose is an unhelpful one, and one which has assumed too much importance after Williams. In the words of Lord Justice Mayles, and I quote, "The statutory words, deliberately concealed, are ordinary English words which ought to be capable of being interpreted according to their natural and ordinary meaning in their context and in the light of the statutory purpose, which is to extend the primary limitation period in cases where the defendant's conduct has prevented the claimant from realising that she has a claim. A judge ought to be able, having ascertained the facts, to decide whether there is a relevant fact which has been deliberately concealed. That ought not to be a complicated question." Close quotes. He held that on the facts there probably was active concealment by Canada Square if that was a relevant issue. The point he made was that where a party takes extensive steps not to disclose a fact it knows is relevant to a claimant's cause of action, at some stage it moves from non-disclosure to active concealment. But where the line is doesn't matter because you just apply the words of the statute. Second, after a close analysis of the judgment of Lord Justice Buxton in Williams that there is no need for a claimant in a non-active concealment case to establish that the defendant was under a pre-existing legal duty to disclose. Rather, there may be, in an appropriate case, a duty to disclose which arises for the purposes of Section 32 from a combination of what the Court of Appeal called utility and morality. In other words, if the court considers that the circumstances are such that the defendant could and should have disclosed the relevant fact, it does not matter that there was no contractual or tortious duty to disclose it. Third, the test for whether conduct is deliberate under Section 32(1)b and Section 32(2) is the test of recklessness as set out by Lord Bingham in the case of R&G. It has both a subjective and an objective element and was expressed in this way, open quotes, "A person acts recklessly with respect to a circumstance when he's aware of the risk that it exists or will exist and it is in the circumstances known to him unreasonable to take the risk. A person acts recklessly with respect to a result when he's aware of the risk that it will occur and it is in the circumstances known to him unreasonable to take that risk." Close quotes. Applying those principles, a Court of Appeal found that Canada Square did deliberately conceal the existence and extent of the commission, which was a fact relevant to Mrs. Potter's right of action, and so limitation was postponed until she discovered the concealment in November 2018. They also found that Canada Square deliberately committed a breach of their duty to her under Section 140A in circumstances where that breach was unlikely to be discovered for some time. So where are we now? Well, the law has been the subject of welcome clarification. The words deliberate concealment we now know are straightforward words which can be applied by judges in a common sense way. All those cases since Cave have led us up the garden path. Subject to any further decision from the Supreme Court, it's now settled that Section 32(1)b is not confined to cases of active concealment, that a pre-existing legal duty to disclose is not a prerequisite to deliberate concealment in a non-active concealment case, and probably most importantly, we finally know that deliberate for the purposes of Section 32(1)b and Section 32(2) means reckless in the sense explained by Lord Bingham in R&G. We also know that the Plevin bandwagon will roll on, with many more old cases being available to be litigated than would have been the case if the Court of Appeal had decided Mrs. Potter's case differently.
The preceding 2 years have been a struggle for some businesses who have been compelled by law to close their doors to customers. Most directors have faced difficult decisions regarding their business's rent liability, but the government has, during the pandemic, stepped in to shield most from the usual and immediate effects of an inability to pay rent, including by suspending forfeiture actions, restricting winding up petitions, and by restricting the use of the Commercial Rent Arrears Recovery Scheme. The government is now rolling out what is perhaps the final say on the issue of recovery of commercial rent arrears accrued during the pandemic. This is the Commercial Rent Coronavirus Bill 2022. It will be in force from late March 2022, and it will bring a sea change with it. It will, in effect, suspend most of the conventional remedies to recover rent arrears in favour of a new statutory arbitration scheme. And with new draft statutory guidance issued on the 23rd of February of this year, we are now able to look at some of the finer points of how this regime will operate in practice. In the course of this talk, I will address 6 common questions about the new regime. And the first is a simple one. What will this bill do? The central purpose of the bill is the introduction of a legally binding arbitration process for commercial leases to resolve claims of unpaid rent that have accrued during periods of enforced closure. So, for example, pubs, gyms, or restaurants that haven't been able to pay their rent during the pandemic. This regime, the arbitration regime, will replace all the existing restrictions currently in place with a new moratorium. The moratorium will prevent landlords from exercising their usual remedies while the application period for arbitration is open or while arbitration is in progress. The bill, however, will only apply in respect of certain ring-fenced rent arrears. The second question is therefore, who will be caught by this new law? It's aimed at business tenancies, and business tenancies to which Part 2 of the Landlord and Tenant Act 1954 apply. This, it is envisaged, should apply to all commercial leases, underleases, periodic tenancies, and tenancies by way of estoppel. Even with contracted out leases, it should still apply. But conversely, and by way of examples, it won't apply to tenancies at will, farm business tenancies, or agricultural holdings. The third question is, what debts will be covered under the new bill? Protected rent, which is a new phrase, is what is covered by the bill. Protected rent is, in short, rent attributable to a protected period that was payable under a tenancy that was adversely affected by coronavirus and linked to that period. The definition of rent is relatively broad. It includes service charges, insurance, interest, and value-added tax. And the definition of protected period means from the 21st of March 2020 to the date when specific restrictions were last removed for that business sector. For instance, the new code gives examples of garden centres. For garden centres, the period will be from the 21st of March to the 13th of May 2020. For non-essential retail, it will end on the 12th of April 2021. This raised initially a thorny legal question of rent arrears for sectors that moved in and out of trading restrictions during the pandemic. For example, businesses that could still trade profitably, such as restaurants offering takeaway services. But it appears now that the fact that limited specific activities were allowed by regulations from time to time will be disregarded. This is what the new code provides for. The new code also gives the example of retail shops that weren't allowed to be open but could permit collection of clothing and other goods. That is to be disregarded. The fourth question is therefore, what are the actual remedies open to landlords to recover commercial rent arrears. The bill contains provisions that prevent landlords who are owed protected rents from using certain remedies such as forfeiture action for a period of 6 months from the bill being enacted. That is the moratorium period. Landlords will be prevented from starting debt claims to enforce protected rent, using the CRAR scheme, presenting winding up petitions, and importantly, prevented from enforcing, by action or otherwise, a right of re-entry or forfeiture for non-payment of a protected rent. Now, curiously, a superior landlord will still be able to enforce a right of re-entry or forfeiture in relation to a head lease during that 6-month period. Sensibly, if a tenant breaches other provisions of the lease, such as causing damage to the property during that time, there will still be a right to forfeit or re-enter. And encouragingly for landlords, no conduct by them during the moratorium period, other than an express waiver in writing, will be taken as waiving a right of re-entry or forfeiture. The fifth question is, how will this play out in practice? Well, the bill and its new code envisage a quasi-pre-arbitration protocol and a binding arbitration process. As part of this, the new code encourages transparency, collaboration, a unified approach, acting reasonably, sensibly, and aiming for a swift resolution. In practice, where the landlord and tenant cannot reach an agreement about protected rent arrears, either party may refer the matter to arbitration within the period of 6 months from the day when the bill is passed into law. The first step will be a letter of intention sent to the other side. In other words, a party must make clear they intend to refer the case to arbitration and should make a proposal for settlement with that letter. This then sets in motion a series of exchanges between the parties. The other party, the receiving party, has 14 days to respond, which can include a counteroffer, and there's then another 2 weeks to consider that counteroffer, following which the application for arbitration is made. The application itself should include the best, final and formal proposal for settlement, together with all supporting evidence. And of course, the other side has an opportunity to do the same. The arbitrator may then make an award on paper or following a hearing, if that's requested, and that should be done within 14 days of the request. An arbitrator, however, may reject the application where a tenant is subject to insolvency arrangements relating to that protected rent debt, or where the tenant's business is simply not viable. I will return to that shortly. The sixth and final question is how an arbitrator will decide the case. The role of the arbitrator, the overriding objective of the arbitrator, will be to determine whether a tenant should receive relief from payment and to what extent. The arbitrator should make a determination that is aligned with 2 core arbitrator's principles. And these are, first, where the tenant's business is viable or would become viable if the tenant were to be granted relief from payment of any kind, any award should be aimed at preserving or restoring the viability of that tenant's business, so far as that is consistent with preserving the landlord's solvency. And the second principle, so far as it's consistent with the first, is that tenants should be required to pay protected rent in full and without delay in accordance with their agreed obligations. The new code has helped clarify how arbitrators will assess a tenant's business's viability. they will have regard to factors such as previous rental payments made under the tenancy, including whether the tenant has since been able to make payments since restrictions were lifted, the impact of COVID-19 on the business, including performance since March 2020, any lost contracts, the insolvency of major clients of the tenant's business, and government grants or assistance received during the pandemic. The arbitrator will also consider the assets and liabilities of the tenant, including multiple debts owed to the same landlord, and any other information, including expert opinion, about the business's viability. The question of the solvency of the landlord is far more straightforward. The arbitrator will have regard to their assets and liabilities and any other information deemed relevant. Notably, arbitrators and practitioners are expressly warned to be alive to parties manipulating their financial affairs, such as to improve their chances of success in the arbitration. And the arbitrator must also ignore the possibility of businesses borrowing money to support their viability. Ultimately, where parties put forward proposals, the arbitrator can choose between them and choose the one which is most consistent with the two core principles mentioned a moment ago. Otherwise, arbitrators must make whatever award they consider appropriate, applying those two principles. As we move forward with the regime, arbitrators must publish their awards, together with the reasons for making those awards, subject to confidentiality provisions. We should therefore slowly begin to see, as the regime takes hold, how arbitrators are developing their approaches and why. Finally, as to the all-important question of costs, costs are generally to be borne by each party, but the applicant may be reimbursed half their fees for the arbitration by the other side. Those are the 6 common questions about the bill and the new code. Overall, this new regime should hopefully provide a fair forum by which to adjudicate on a pervasive issue affecting businesses in this country. There should be no doubt that this scheme will be busy. For instance, the government recently reported that hospitality rent payments continue to lag behind. And in the pubs, bars and restaurants sector, just 28.4% of rent was paid 90 days after the March payment date. What's more, this scheme could very well be with us for far longer than the 6-month moratorium period. The Secretary of State is specifically empowered to extend the 6-month moratorium period, which may be an indicator of what is to come. Either way, this bill will become law. The new regime will be in force from the end of March of this year. But the newly published draft code is just that, a draft. It's subject to change, and the government has invited comment on how it will operate in practice. Thank you.
In April 2013, the Jackson reforms highlighted that late amendments to statements of case were causing delay, additional stress and increased costs to parties. Following this, the direction of travel has been towards an ever stricter approach to late amendments. In this short seminar, I will examine the current approach of the court to late, very late, and post-trial amendments to statements of case. Historically, the starting point for the questions of amendment was the judgment of Lord Justice Peter Gibson in Cobbold, which he said, amendments in general ought to be allowed so that the real dispute between the parties can be adjudicated upon, provided that any prejudice to the other party can be compensated for in costs. As I will discuss, the position has moved on considerably from this. and in what follows I will outline the considerations of the court when faced with a late, very late and post-trial application to amend. What is a late application to amend? Well, the question of whether an amendment is late or very late is not only answered by the reference to the stage in the proceedings that it comes at. Rather, it requires an analysis of the nature of the proposed amendment and consideration of its knock-on effect. As a starting point, it's likely that any application to amend which is made following the case management conference, and certainly following the PTR, are likely to be considered late. However, lateness is a question of degree. The greater the duplication of work already done, which will be generated by an amendment, the later it will be considered to be. For example, if an amendment requires substantial redrafting of witness statements, that will be a factor which counts against it and points to it being a late amendment. Support for the propositions I've just set out comes from the cases of Tesla Motors and Another and the BBC, and LBI-HF and Landesbanki, and the judgments of Lord Justice Moore-Bick and Mr. Justice Nugi, respectively. A further definitional distinction is drawn between late and very late amendments. In essence, a very late amendment is one where the trial date has already been fixed and an amendment will cause this to be lost. This is a definition taken from the leading judgment of Mrs. Justice Carr in Kwa Su Ling and Goldman Sachs. As is apparent, this requires consideration not only of the date of the amendment, i.e. how close it is to trial, but also its substantive nature. A minor amendment, which is unlikely to affect the evidence required at trial or amend substantially the issues in the case, is unlikely to be considered a very late amendment, even if made late on in the day. There is a third category of amendments, that is to say those that are requested after a trial but before a judgment has been handed down and an order sealed. These applications involve distinct issues and I will deal with them discreetly in due course. So turning from definitions to principles, how does the court approach a late application to amend? The leading modern case on late amendments is probably that of CIP Properties and Galliford, a High Court decision by Mr. Justice Coulson. At paragraph 19 of that judgment, the judge set out a comprehensive list of considerations for the court when dealing with a late amendment. I won't repeat them in full here, but broadly, the judge concluded that the party seeking to amend has to put forward a good reason for the delay. The relative prejudice to both parties is an important factor for the court and has to be balanced, and that the less particular the amendment, the less likely it would be to succeed. In the 2019 High Court case of Essex County Council and UBB, the High Court outlined the following additional factors. Firstly, the timing of the application. In short, the earlier that an application to amend is made, the more likely it is that a court will accept it, and consider that on the balance of prejudice falls in favour of the would-be amender. The second factor is that in balancing the factors in coming to a conclusion, the court ought to have regard to the overriding objective to ensure that litigation is pursued reasonably and proportionately. Turning to the question of very late amendments, the approach of the court as regards these is set out in the judgment of Mrs. Justice Carr in Kwa Su Ling, to which I have already referred. In that case, the court set out that in addition to the factors I've already covered under the heading of late amendments, some additional considerations come into play. Generally, as with late amendments, the question of amendment is a discretionary one. The overriding objective is of great importance for the decision of the court in exercising that discretion. As such, any application will always involve balancing injustice between the applicant, respondent, and other litigants in general. Where an application is very late, the applicant bears a heavy burden to show the strength of their new case, and why justice requires them to be able to ventilate it. The inherent risk to a trial date will often mean that that balancing exercise is very heavily loaded against the party seeking to amend. A costs order is not generally considered sufficient to compensate a party for the prejudice of facing a substantial late amendment which would involve the loss of a trial date. Following the implementation of the CPR and the Jackson reforms, Mrs. Justice Carr observed that justice now means something different, and the parties should not inspect the indulgence of the court when they fail to comply with directions and/or seek to bring late amendments into a trial. A slight caveat to this general approach was set out in the case of MBI International Partners Incorporated. In that case, the application to amend was made during the trial itself, so on the face of it very late, but was prompted by some late disclosure and evidence. As that application could not have reasonably been made earlier, the requirement for the applicant to justify the amendment was not considered to be as heavy, although the court was still required to carry out the same balancing exercise. I turn now to post-trial applications to amend, i.e. amendments that are sought after the circulation of a draft judgment, but before that judgment has formally been handed down and the order sealed. It's important to note that once an order is sealed, the only challenge that can be made is by an appeal, and this jurisdiction, which I'm about to discuss, will evaporate on that step being taken. There is no discrete provision within the civil procedure rules which covers an application to amend post-trial. There are two species broadly of these applications. An application can either be made to invite the judge to reconsider their judgment in light of an amended pleading, or rather to invite them to reopen the trial and try an additional claim which is pleaded after the circulation of a draft judgment. The principles that apply to both have much in common, although where a trial is to be reopened, some additional factors will come into play. Dealing with an invitation to the judge to reopen their judgment and reconsider it in light of an amended case. This jurisdiction was formerly known as the Barrel jurisdiction, after the decision of the Court of Appeal in Re Barrel Enterprises, which was subsequently followed by the Court of Appeal in the 2000 case Stewart and Engel. In brief, this line of authority required there to be exceptional circumstances for any amendment to pleadings post-trial. However, in 2013, the Supreme Court, in the case of Re L&B, gave a unanimous decision which disproved this approach. Rather, in the view of the Supreme Court, when a judge is faced with an amendment to amend pleadings and an invitation to reconsider their draft judgment, the relevant consideration falls to be considered under the overriding objective. There is no formal requirement for exceptional circumstances. As such, similar considerations to late and very late amendments will be relevant. Dealing with the second category of case, i.e. where a party seeks to reopen a trial and advance a new cause of action following a judgment, the court is also required to consider the overriding objective, and by analogy, the authorities on late and very late amendments that I have already discussed, to undertake a balancing exercise. Whilst the court is not being asked to vacate an existing trial date, but to list a new one, the request for a further trial to ventilate issues which could have been dealt with in the first trial will generally be treated the same way. Furthermore, where a further trial is requested, the court will look very carefully and be especially concerned with the interests of other litigants who will be potentially prejudiced by a second trial being listed in the same matter. As an additional consideration, when an amending party seeks to adduce new evidence in support of their claim, the Ladd and Marshall factors will apply to that evidence, and the applicant will have to satisfy the court as to those factors before any additional evidence can be relied upon. In the recent High Court case of Bioconstruct and Winspear, in which I represented the successful respondent, the court faced a post-trial application from a claimant to advance a hitherto unpleaded claim in deceit, along with a request to reopen the trial. The judge, after considering the principles I have discussed, rejected that application. As a part of striking the balance in bioconstruct, the court also considered the timing of the application, which had been served 1 working day prior to the handing down. The judge accepted that the applicant had been planning this application for some time prior to this. In bioconstruct, the judge agreed with the submissions of the respondent that once an applicant had in mind they would be making a late application to amend or a very late application to be amended, it was incumbent on them to inform their opponent of the prospect of such an application being made, even if full particulars could not have been given. That is consistent with their duty under the overriding objective and the general cards-on-the-table approach to civil litigation in the CPR. The lateness of the application in bioconstruct and the failure to provide even informal notice in advance of it being made provided another strike against the applicant in the balancing exercise undertaken by the court. As such, when preparing an application to amend, whether pre or post-trial, it is important to alert the respondent to your intention, even informally, as early as possible.